Thank you, May it please the Court. My name is Ben Sorber, and I represent the appellant, Kyle Kordich. Before I proceed, I would ask that the balance of my time, up to 5 minutes, be reserved for rebuttal. This case presents two issues for the Court to consider on appeal. One, did the trial court err when it found there was reasonable suspicion to stop Mr. Kordich's vehicle? The second issue that presents is, did the trial court err when it found there was probable cause for the officer to effectuate a warrantless arrest of Mr. Kordich for driving while intoxicated? As to the second issue, I would just defer to my brief for the purpose of oral argument today and focus on that first issue for the Court. In order for an officer to conduct a traffic stop, he has to have a reasonable, articulable suspicion that there is some sort of criminal activity afoot. When reviewing the officer's reasons for stop, the Court uses an objective standard. So would a reasonably cautious person, believe that the stop itself was justified based on the facts and circumstances known to the officer? In this case, the traffic stop of Mr. Kordich fails that test. The officer observed Mr. Kordich as the officer was sitting along the side of the road. He saw Mr. Kordich drive by. As Mr. Kordich drove by, the officer noticed a white light coming from the side of Mr. Kordich's vehicle. At the time he saw Mr. Kordich's car drive by, the officer said he wasn't sure what the light was or where it was coming from. So he pulled out onto the road to follow Mr. Kordich and investigate. For the next quarter mile to half mile, the officer followed Mr. Kordich. As he did, he could see the light was coming from the side of Mr. Kordich's taillight area. While he was following Mr. Kordich, the officer did not observe any other traffic violations. Then Mr. Kordich slowed down, used his turn signal, and pulled into a convenience store. The officer followed him in and immediately turned on his overhead lights and initiated a traffic stop. Now, the business that Mr. Kordich pulled into was closed at the time, but the officer testified that the light of the sign for the business was still on. The business had been open within the past hours. It's a business that's normally open late at night. And he also said that if Mr. Kordich had pulled in and turned around, he wouldn't suspect anything criminal about it. He also testified he didn't see any traffic violations while he was following Mr. Kordich. So we can focus on the taillight itself when determining the basis for the officer's stop. Now, under Ohio law 15CA0058, only one taillight is required to be operable on the rear of a vehicle. The officer testified that he was also aware of that. Now, this court held in State v. Fry that only one working taillight is required. But the court went a little farther than that. In State v. Fry, this court said that the legislature has chosen not to make having one broken taillight a crime. Such a stop would be akin to the random detention struck down by the U.S. Supreme Court in Delaware v. Prowse. In this particular case, the traffic stop of Mr. Kordich, based on the one crack in his taillight, was akin to a random stop that this court struck down in State v. Fry and the U.S. Supreme Court struck down in Prowse. Now, the officer testified that the white light was coming from the side of the vehicle, and that's why he cited him with violating another section of the code, which is Revised Code 451313. This section deals with cowl, fender, and backup lights. But even under this section, side lights can illuminate white light, and that's the case that we have here. That's what distinguishes the present case from the cases relied upon by the state. And that's, in particular, State v. Stover and State v. Flores. Those are two cases that this court considered in 1995. And in both of those cases, this court upheld the traffic stop based upon white light coming from the rear of a vehicle. But the facts of those two cases distinguish it from the present. Particularly in Stover, the officer testified that the white light coming from the rear of the vehicle was dangerous because cars traveling behind the car he stopped, the drivers would be blinded by that white light. And so that's why he needed to initiate a traffic stop in that case. In State v. Flores, The officer testified he stopped the vehicle because the white light coming from the rear of the car was dangerous because it looked like a backup light. And backup lights can't be illuminated when a car's traveling forward. He said the white light in that case was dangerous because it could confuse other drivers. They could think the car was in reverse and take evasive action, which could cause accidents. We don't have that in this case.
So in this case, what the officer ultimately discovered was that the white light was coming from the tail light. Is that correct?
It was coming from the taillight housing, but he said it was on the side. It was a small crack in the side. As he was driving behind the vehicle, it wasn't necessarily shining in his face like a reverse light would, but it was coming kind of from the side.
So I guess my question is that the place where a white light would, from which a white light would come if it were a backup light?
I don't believe it would. I think
Do we know that from the evidence?
we do, because the officer said that this was coming from, he said it was coming from kind of the side portion of the car. We also have
But the side portion of what?
the side portion of the light unit,
But-
the tail light unit.
But we have to look at what the officer observed when the car was being driven, not what he found out after the fact, right?
Correct. And as he's watching the car being driven, he's noticing that the light is coming from the side of the taillight unit as opposed to a backup section.
And didn't he testify that he didn't know where that light was coming from?
He testified that he didn't know where it was coming from until he pulled out and was following it. And then I believe he testified he could see it coming from the side. I think what's also unique about this case is that we have, as part of the record, the video taken from the officer's dash cam. And if you watch that video, as he's following him, you don't see the white light coming from it. So this isn't a case where other drivers, other motorists would be blinded by the white light. And it's not a case where the white light looks like a backup light that's on. This is just a small crack that's allowing some white light to come through where there would be a red, I don't know, reflector or part of the taillight unit on the side.
So clearly, in terms of establishing not probable cause, but reasonable suspicion for a stop, the officer doesn't have to know for a certainty that this is or is not a backup light. But if the officer has a reasonable suspicion that there is a violation, even if that suspicion turns out not to be founded, doesn't that support the stop, the traffic stop?
It would, Your Honor, if it is a reasonable suspicion. But in this case, the officer, he followed Mr. Kordich for about a quarter mile to a half mile to kind of investigate where the light was coming from. And during that time, I believe he was able to determine that it was coming from the side of the housing unit. He didn't believe this to be a dangerous condition, and he didn't believe it to be a reverse light. Even after he stopped Mr. Kordich, he wasn't unsure of how to cite this. He said he went back and reviewed a cheat sheet to determine what section it would probably fall under. I don't believe this is a case where the officer reasonably believes there's a traffic violation. I think this is a case more where he saw a light, he wasn't sure what it was, and on a hunch, effectuated a traffic stop. And that doesn't comport with the Fourth Amendment. So based upon that, we would ask that the court would reverse the trial court's ruling upholding the traffic stop and remand it with an order to suppress the traffic stop and all evidence obtained as a result of that. Thank you.
Thank you. You may proceed.
May it please the court, my name is Greg Huber. I represent the state of Ohio in this case. Let me first address the question of reasonable and articulable suspicion. The statements by the appellant counsel with respect to the facts in this case, frankly, are just not accurate at all. I know the testimony from the officer at the hearing that was conducted before Judge Chase set out page 11 of the transcript of the hearing. This taillight issue is not from the side of the car. The officer saw a white light from a red Volvo as it passed him. This happened at 12 o'clock at night. It was dark out, the vehicle's lights were on, and as the vehicle passed, he saw a continuously shining white light. He could not tell exactly where it was coming from, so he pulled out and followed the vehicle, and the officer testified on page 11 as follows. I could see the white light, but he was still some distance ahead of me, so I couldn't make out exactly where it was coming from. Then as he is getting closer, he is asked this question, was the white light constant? The officer testified, yes, it was constant. And then the next question on page 11 asks, and although at this point you didn't know exactly where it was coming from, was it from the center of the vehicle, the side of the vehicle? And the officer testified it was through the right rear corner of the vehicle. Next question, is that in the area where there is a tail light there? Yes, in the area of the tail light. So the characterization of the white light from the side of the vehicle is not what the officer testified to. It's from the tail light area. Now the revised code states that if you have a backup light that is continuously operating when the vehicle is in forward motion, it constitutes a traffic violation, and that section is 1513A. Now this officer identified at that point in his testimony the reason why he was following. This is a continuously operating white light in the taillight area, and it would reasonably, at least for an officer investigating, constitute a possible violation of that code section. And moreover, revised code section 4513.02B permits an officer to stop the vehicle for purposes of inspecting an unsafe condition, which is exactly what was on the mind of the officer at the time. And if he
But the
saw,
officer didn't say that he regarded it as unsafe, did he?
he wouldn't have to. If it's a continuously operating white light, he would not have to testify to that. This court never said that in the Stover case or in any other cases.
What about the case that talks about that an individual needed to have only one operated tail light?
Well, for purposes, this goes right to the question you asked. He wouldn't know exactly, as he's reasonable articulable suspicion doesn't require that level of knowledge as he's pursuing this vehicle. The statute says a continuously functioning white light, backup light, when the vehicle is moving forward is a traffic violation. That's what he's seeing, and he's identifying it coming from the tail light. Now at page 40, after he got to the point of talking to the defendant and actually inspecting the tail light, he testified at one point, when I walked past the light, when I moved my camera, I actually observed the tail light was cracked and broken. So this literally is identifying the area where the light is coming from.
Is there any testimony as to, and maybe everyone assumed that people would know, the difference between the location of brake light, tail light, backup light, and whether or not they are housed under the same, reflective shield, so to speak?
Well, I don't think that level of specificity actually garnered testimony. We do have a video of the rear vehicle, so the judge could look at how the taillight configuration was set up on the Volvo.
But I just don't know if, and certainly we'll look at that, I just don't know unless, for example, the officer said, okay, put your car, put your foot on the brake. Now, put the car in reverse so that the camera would be able to depict the difference between
of specificity of questioning did not occur in this case. But respectfully, for purposes of reasonable and articulate suspicion, if this officer sees a continuously functioning white taillight and he identified it coming from the taillight area, I don't know where my colleague is getting statements concerning the side. That didn't happen. This is the taillight, and this is right in the area where the backup light would be, because that is a part of the taillight assembly. So this is an officer who he identified how it is that this was a continuously functioning white light, because he finally figured it out. I think he cited him wrongly. He cited him for the 15CA0058 violation, a continuously functioning backup light. At trial, we wouldn't be able to establish that case because the taillight is you only require one. That's why the Fry case is distinguished from this case. The Fry case actually involved a situation where there was a taillight issue. This was a backup light question. And the officer's reason for pulling out and his reason for our suspicion involved a violation of 4513A. And frankly, I would think that a good officer would be expected to see that and inquire, perhaps stop the vehicle, issue a warning, or issue a ticket, depending upon what he did. Issue a ticket for the backup light violation. He asked for this gentleman's identification. Immediately, the defendant's ability to produce his license was less than what the officer would expect from a sober person. He testified to that. Immediately noticed an odor of alcohol. Immediately noticed bloodshot, glassy eyes. The store that he pulled into was closed. In the videotape, it's closed. Why would anybody see? You can see it's a closed store. The building next door is vacant. The officer had a question as to why, when he's behind him, he would pull into a closed store, which is not a violation, but is a question an officer will ask himself.
Is this the case? We had several of these today and Thursday. But is this the case where the officer testified about getting some conflicting responses about pizza and whether he was
Exactly.
going to pick up pizza?
Right. The police officer asked him where he was coming from and where he was going. The testimony was confusing. Initially, he said he was coming from home. Then he said he was going home. The officer asked him about more questioning about what he was doing on the road, and the defendant testified that he had come from Panini's, but that he was going to get pizza, and the officer saw the pizza box on the passenger side, and he also saw two 40-ounce tall boy beers located there.
Full or empty?
Full, I believe. We have photographs of the beers. So the explanation seemed odd, probably not illegal, but it didn't quite add up. The officer at that point asked the gentleman to step out. He asked him about prior OVI convictions. Initially, the man said he had none. Then he said he had one 4 or 5 years ago. The officer went back and checked. He had an OVI violation in 2008 and in 2012. The 2012 violation was a refusal. Ultimately, he administered field sobriety tests, felt that the gentleman was under the influence of alcohol enough to take him back for a test, and the gentleman refused the breath alcohol test. We would respectfully assert that the chain of events that occurred in this case would be in accord with what this court analyzed in the Stover case. The issue with respect to the white light would be a basis for the officer to stop and investigate a possible unsafe condition. It's exactly what this court upheld in the Stover case. I'm not sure where the counsel for the appellant is saying like white lights from the side, therefore he should have known better than to stop him. That didn't happen in this case. This is a taillight issue. It's the same taillight assembly. We would expect any good officer, if he so chooses, to inquire and ask the person driving the vehicle, or at least find out why this continuously operating white light is functioning the way it was. Thank you. I'm
Thank you. Counsel, you've got 5 minutes. Here, your seat.
Thank you. The white light in this particular case, the officer never testified that he believed it to be a dangerous condition. So stopping the vehicle to investigate a dangerous condition doesn't apply. We just don't have that testimony in the record. Nor did he testify that he believed it was a backup light. Based upon the housing of that unit, he testified it was a small crack. He said that the light itself, there was still enough of a reflector as part of the taillight to reflect his headlights. He said that while the taillight unit had a crack in it, it was not completely open.
But counsel, again, that is after the fact. We have to go by what the officer observed when he was observing the car and following the car.
Right, but while he was following the car, you can see in the video from his dash cam that, that there's still reflection of his headlights on the taillight unit. You don't see a backup light on. The camera's not catching any glare from white light shining from the rear of his taillight. So the taillight doesn't look like it's got a backup light that's on in violation of the revised code. And it doesn't present a dangerous condition where it's blinding other drivers behind him.
Does it look exactly the same as the one on the other side of the car?
I believe it does.
Except for the white light.
I don't believe that you can see the white light in the video itself as he's following. It's not completely clear, but as he's following him, you don't notice any glare coming from the camera. It doesn't appear that there's a backup light on, and that's true after the car pulls into the gas station and the lights are off. But you can see after the officer turns off his red and blue flashing lights, you can see that both taillights are reflecting the headlights of the patrol car. So this case is different from the Stover case where there was a dangerous condition. It's different from the Flores case where the officer testified it looked like constant backup lights. While the taillight itself may have been cracked and may have been emanating a white light someplace in there, it's not a violation of Ohio law, nor is the officer able to really articulate that he believed this was a violation of Ohio law. Based upon that, this stop was not justified, and we would ask that the court would reverse the trial court's opinion.
Thank you, counsel.
Thank you.
Thank you both for your arguments to the court. The court will take the matter under advisement and will issue a written opinion to be sent to both sides.